There are moments in American history where you just remember exactly where you were when you heard the news. The Challenger explosion, September 11th. And for those of us who have spent our lives studying the Second Amendment, who have followed the twists and turns of the Supreme Court for decades, January 20th, 2026 is going to be one of those dates we never forget. The news hit the wire, and within minutes, my phone was blowing up. Texts, emails, social media notifications, all asking the same thing. Did you see what they just did? The Supreme Court, in a 6-3 ruling, dropped a bombshell that has completely redefined the landscape of self-defense in this country. And the thing is, the mainstream media is doing what it always does, missing the point entirely, simplifying it into a soundbite, and leaving millions of gun owners confused, scared, and dangerously uninformed. Here's the question I need you to answer in the comments. After hearing about this ruling, what was your very first instinct? Did you feel a surge of relief that your rights were protected, or did a knot form in your stomach because you immediately saw the loopholes and the traps that are still out there? Seriously, scroll down and let me know. I read every single one of your responses, and I want to see where the collective mindset of the American gun owner is right now. Because depending on your answer, it tells me whether you're seeing the surface-level headlines or whether you're seeing the game of chess that's actually being played here. And trust me, if you think this ruling just gave you a free pass to carry your firearm anywhere, anytime, with no consequences, you need to keep reading because I'm about to explain why that assumption could land you in handcuffs faster than you can say, "shall not be infringed." I've spent the better part of 3 decades traveling across this country, studying not just the letter of the law, but the behavior of the men and women who enforce it. I've sat in federal air marshal briefings, I've debriefed with TSA agents after shifts, and I've talked to sheriffs in rural counties who laugh at the same gun laws that give chiefs of police in major metropolitan areas nightmares. The law is rarely about just the words on the paper. It's about the interpretation, the culture, and the practical application on the ground. And this new ruling, it's a seismic shift, but it's also a trap for the unwary. Let's rewind for a second. To understand why this ruling is such a shock, you have to understand the battle that's been raging since 2022. That was the year of the Bruen decision, the New York State Rifle and Pistol Association versus Bruen case that fundamentally changed how we look at the Second Amendment. Before Bruen, courts used a 2-step test that basically allowed states to balance away your rights. They'd ask, is the conduct covered by the Second Amendment? If yes, they'd then ask, is the government's interest important enough to restrict it? That interest-balancing test gave anti-gun states a blank check to deny permits, restrict carry locations, and make life miserable for law-abiding citizens. Bruen threw that out the window. Justice Thomas wrote the opinion and said essentially, stop balancing, stop weighing interests. If the Second Amendment covers the conduct, the government has one job: prove that the restriction is consistent with the nation's historical tradition of firearm regulation. If they couldn't find a historical twin from the founding era, the law was dead. Now, for the last 4 years, we've been watching the lower courts twist themselves into pretzels trying to get around Bruen. They were looking for loopholes, and they found one. They started creating what I call the sensitive place explosion. Bruen said you could ban guns in sensitive places like courthouses and schools, but it warned that you couldn't just declare someplace sensitive because it was crowded. Well, states like Hawaii, California, New York, and New Jersey looked at that and said, hold my beer. They passed laws creating massive sensitive places that covered just about everywhere you might actually need a gun for self-defense. And that brings us to the case that just broke the system. Woolford v. Lopez out of Hawaii. This case is the hammer that just smashed the glass. Jason and Allison Woolford, a typical American couple, challenged a Hawaii law that did something truly insidious. Hawaii passed what the NRA brilliantly dubbed the vampire rule. The idea that, like a vampire, you cannot enter private property that's open to the public unless you're explicitly invited in. Under this law, unless a business owner posted a sign explicitly saying guns allowed, you were presumed to be committing a crime if you carried your concealed firearm onto their property. Think about the absurdity of that for a second. In most of America, the default is freedom. You can carry until someone tells you not to. In Hawaii, the default became prohibition. You couldn't carry until someone gave you permission. The implications were staggering. You want to stop at a 7-Eleven to grab a soda? That's private property open to the public. No sign? You're a criminal. You need to go to the mall? Same deal. A restaurant, the hospital, a gas station? The Woolfords argued that this made it impossible as a practical matter to carry a firearm because you'd have to get written permission from every single property manager just to run your daily errands. The Ninth Circuit, that reliably reversed bastion of liberal judicial activism, actually upheld this law. They dug through history and found two examples they claimed were dead ringers: a 1771 New Jersey law about hunters trespassing, and an 1865 Louisiana law that was part of the Black Codes, designed specifically to disarm freed slaves. They used racist Jim Crow laws to justify disarming free citizens today. You can't make this stuff up. So here we are. January 2026, the Supreme Court hears oral arguments. And the tone of the questioning told you everything you needed to know. The liberal justices, like Justice Jackson, were trying to frame this as a property rights issue, not a gun issue. They were arguing, well, the property owner has a right to control what happens on their land. And on its face, that sounds reasonable. But Justice Alito, in a moment of sheer brilliance, dismantled that argument. He posed a hypothetical. What if a state passed a law saying that, by default, you cannot wear a shirt supporting a political candidate into a restaurant unless the owner posts a sign allowing it? Would that be constitutional? Of course not, because it would be a state-sponsored infringement on your First Amendment rights, hiding behind the guise of property law. The Second Amendment, the court made clear, cannot be eviscerated by clever property law drafting. And then came the moment that really sent shockwaves through the legal community. Justice Kavanaugh, who is often the swing vote, looked at the defenders of the Hawaii law and said, essentially, why are we making this complicated? The text covers arms. Heller says there are exceptions rooted in history. There's no sufficient history supporting this regulation. End of case. He was signaling that the historical examples the state brought were garbage. The New Jersey law was about trespassing hunters, not licensed citizens going to the grocery store. And the Louisiana law? As Justice Alito pointed out, the idea of citing a racist, unconstitutional black code to interpret the Second Amendment is the height of irony. When the final 6-3 ruling dropped, it was even broader than many of us anticipated. The court didn't just strike down Hawaii's vampire rule, they established a clear precedent that states cannot create default prohibitions on private property open to the public. The court reaffirmed that the default setting in America is that if a place is open to the public, and you are a law-abiding citizen with a right to carry, you can carry unless the property owner explicitly opts out. The government cannot opt you out by default. Now, here's where we get into the weeds, and here's where that question I asked earlier about your gut reaction really matters. If you felt relief, you're probably thinking, great, my rights are expanding, the courts are protecting us. And you're right, to a point. But if you felt that knot in your stomach, you're probably seeing the same thing I'm seeing, a massive, confusing patchwork that is about to get even more chaotic before it gets better. Because while the Supreme Court just handed us a huge win on paper, the practical reality of traveling and carrying in the United States in 2026 is still a minefield. And frankly, this ruling might have just made the short-term confusion worse for the average traveler. Let's talk about what this actually means for you, your holster, and your next trip across state lines. Because the court can issue all the rulings they want, but they don't issue you a get-out-of-jail-free card if you walk into the wrong place with the wrong permit in the wrong state. First, we have to talk about the concept of sensitive places that survived this ruling. The court was very clear that they were striking down the vampire rule presumption, but they specifically reaffirmed that certain places can still be gun-free zones. We're talking about the core historical exceptions: courthouses, schools, government buildings, and polling places. But here's where it gets sticky. The court also left the door open for states to regulate carry in places that are analogous to those historical exceptions. And that ambiguity is going to be litigated for the next decade. For example, look at what's happening right now with public transit. The NRA just filed an amicus brief in Schoenthal versus Raoul, challenging Illinois' ban on carrying on public transportation. Illinois argues that a bus or a train is a crowded space and therefore a sensitive place. The Seventh Circuit actually agreed with them, inventing a whole new category of crowded spaces that the Supreme Court has never recognized. The Supreme Court hasn't taken that case yet, but based on this new ruling, you can bet they will. And until they do, if you step onto the L train in Chicago with your concealed carry, you are breaking the law. Period. The Supreme Court just protected your right to carry into a Walgreens, but a block away, that same Walgreens receipt in your pocket won't protect you on the subway. This is the kind of granular detail that the casual gun owner misses. They see Supreme Court protects gun rights and think they're invincible. Meanwhile, they're driving through New Jersey, a state I personally refuse to travel through with a firearm. And they have no idea that their 15-round magazine is a felony there. Let me tell you a story that still makes me wince every time I think about it. I had a friend, a former law enforcement officer, who was driving from Virginia to visit his daughter in upstate New York. He did his homework. He checked reciprocity. He had a valid Virginia permit, and he knew New York doesn't recognize it. So, he did what he thought was the right thing. He unloaded his Glock, locked it in a hard-sided case, put the ammunition in a separate locked box, and stored it all in the trunk. He was relying on the Firearm Owners Protection Act, or FOPA, which is a federal law that says if you're traveling from a place where you can legally possess a gun to another place where you can legally possess it, and you're just passing through a restrictive state, you can transport it unloaded and inaccessible. He stopped for gas in New Jersey, paid at the pump, didn't even go inside, got back on the road. 20 miles later, he got pulled over for a taillight that was out. The officer asked if there were any weapons in the vehicle. My friend, being an honest guy and a former cop, said, "Yes, there's an unloaded firearm in the trunk, locked up, and I'm passing through to New York." He thought he was being respectful and lawful. The New Jersey state trooper didn't care. He arrested him. Violation of New Jersey law. His gun was confiscated. He spent the night in jail and paid a 5-figure legal fee to fight it. He was technically protected by FOPA, but tell that to the arresting officer. Tell that to the prosecutor who offered him a plea deal. The law is supposed to protect you, but the reality is that FOPA is an affirmative defense, meaning you're guilty until you prove your innocence in court. That's not protection, that's a lawsuit. This is the world we live in. 29 states now have constitutional carry, or permitless carry. That sounds amazing, right? It means you don't need a permit to carry in your home state. But here's the hidden danger that nobody talks about. If you rely on constitutional carry and you don't have a permit, you are severely limiting your ability to travel. Why? Because reciprocity only applies to permits. If you don't have a piece of plastic that says license to carry on it, states that require a permit have nothing to recognize. You could be a saint, a law-abiding citizen with a clean record, but if you cross into a shall-issue state like Virginia or a may-issue hellhole like Maryland with your permitless carry gun, you are committing a felony the second you cross the state line. And then there's the Gun-Free School Zones Act. This is a federal law that prohibits firearms within 1,000 feet of K-12 schools. There's an exception if you have a state-issued permit. That's the key. The federal government respects your state permit. But if you're carrying without a permit under constitutional carry, that exception doesn't apply to you. So, in a constitutional carry state, you might be driving down the highway. And if that highway passes within 1,000 feet of a school, and in most towns, that's a huge area, you are technically violating federal law. Will you get caught? Probably not. But it's a risk. And it's a risk that a lot of the constitutional carry is the only way crowd conveniently ignores. Now let's throw air travel into this mix, because this is where I see travelers make the most boneheaded, life-ruining mistakes. Flying with a gun is legal. It's perfectly legal. But the process is so riddled with tripwires that I am always shocked more people don't get arrested. The TSA has a list of things you shouldn't pack, and firearms are at the top. You cannot, under any circumstances, bring a firearm in your carry-on luggage. That should be common sense, but every year, TSA posts those photos of the guns they find at checkpoints, and every year, I wonder how many of those people are sitting in a federal holding cell. If you want to fly with your firearm, you have to declare it at check-in. It must be unloaded, and it must be in a hard-sided, locked container, and that lock cannot be a TSA lock. This is a huge mistake people make. TSA locks are designed to be opened by the government. If you use a TSA lock, you are giving up control of your firearm to any baggage handler or TSA agent with a master key. Use a non-TSA combination or key lock that only you control. You keep the keys. You do not give them to the airline. When you declare it, the agent will have you open the case, sign a declaration card stating the gun is unloaded, and you put that card inside the case before locking it. Then, it goes on the conveyor belt into the abyss. Here's the catch. If you have a connecting flight, and especially if that connecting flight is in a state like New York or New Jersey or Maryland, you are playing with fire. If your luggage is delayed, lost, or if you have to claim it and recheck it due to a customs issue or a long layover, you might find yourself physically possessing a firearm in a jurisdiction that doesn't recognize your right to have it. You might be protected by FOPA, but as my friend's story proves, protected by FOPA often just means you have a legal defense that will cost you 50 grand to use. I had a reader once write to me, absolutely panicked. He was flying from Texas to Maine with a layover at JFK in New York. He had declared his firearm in Texas, checked the bag, and landed at JFK. His connecting flight was delayed by 8 hours. The airline offered to let passengers retrieve their checked bags to get personal items. He took them up on it. He walked out of the secure area, claimed his bag, which contained his locked firearm, and suddenly he was in the terminal at JFK Airport, which is a gun-free zone, with a firearm. He hadn't even opened the case. He just had the bag. He realized what he'd done, panicked, and immediately went back to recheck it. He didn't get caught, but he easily could have. That moment of convenience could have cost him his freedom. And this is the crux of the issue. The Supreme Court can define the broad strokes of our rights, but they can't protect us from our own ignorance. They can't protect us from the 1,000-foot school zone, the unfriendly traffic cop in New Jersey, or the airline that loses our bag in Chicago. The Woolford ruling is a massive victory. It tells states like California and New York that they cannot create a legal regime where the default is, you are banned until permitted. It forces them to respect the fact that private property open to the public is not a government-controlled sensitive place. It means that when you walk into a mall in Honolulu next year, the presumption will be that you can carry, just like it is in Texas, unless that mall explicitly tells you not to. But let's look at the other case the court is hearing this term, United States versus Himani. This one is about drug users and gun rights. The question is whether the federal government can ban unlawful users of controlled substances from owning guns. The plaintiff, Himani, is arguing that historically we only banned people who are currently drunk or high, not users in general. The historians are pushing back, saying there were laws against habitual drunkards. If the court rules that the government can ban marijuana users, even in states where it's legal, from owning guns, that's going to affect millions of people. And if you're traveling from a legal state to an illegal state with a gun and a medical card, you're walking into a federal trap. So, where does this leave us? It leaves us with a country that is more divided on this issue than ever. We have 29 constitutional carry states, 12 shall-issue states, and about 9 may-issue or restricted states. That's not unity, that's a fracture. And for the traveler, that means you cannot rely on headlines. You cannot rely on what your buddy told you at the gun range. You cannot rely on common sense. You need to rely on research. You need to look at the actual statutes. There are apps out there like the CCW Concealed Carry 50 State app that update monthly with reciprocity changes in state laws. Use them. You need to look at the Attorney General's website for every state you plan to step foot in. You need to understand that just because a state honors your permit doesn't mean you can carry everywhere. It might honor the permit, but ban you from restaurants that serve alcohol. It might honor the permit, but require you to notify the officer immediately during a traffic stop. It might honor the permit, but have a duty to retreat law that completely changes your self-defense calculus. I remember traveling through Colorado a few years back. Beautiful state. I was there for a shooting competition. I had my non-resident permits. I had done my homework, I thought. I stopped at a state park to take some photos. I had my firearm on me, concealed. I didn't think twice about it because I was in a constitutional carry state. Turns out that specific state park required a permit to carry, even for constitutional carriers. If a ranger had walked up, I could have been cited. I got lucky, but that's the point. Luck is not a strategy. The Supreme Court just reminded us that the Second Amendment is not a second-class right. They just told the states that they cannot use clever tricks to nullify it. They just affirmed that your right to self-defense doesn't evaporate when you walk into a shopping center. That is huge. It is a watershed moment. But it is not the end of the story. It's the beginning of a new chapter, one where the battle shifts from the whether to the where. The anti-gun states are not going to give up. They're going to pass new laws. They're going to redefine sensitive places. They're going to go after magazine capacity. They're going to try to tax guns and ammo out of existence. And in the meantime, you and I have to navigate this mess. We have to be the adults in the room. We have to be more knowledgeable than the average cop on the beat. Because, let's be honest, most police officers don't know the intricacies of reciprocity and FOPA. They know their state law, and if you violate it, they will arrest you and let the courts sort it out. Do not be the test case. So, when I asked you at the beginning whether you felt relief or that knot of worry, I hope you understand now why both reactions are valid. Relief, because we just won a major battle against government overreach. Worry, because the war is far from over, and the battlefield just got a lot more complicated. Before you pack that bag, before you load up the car, before you book that flight, ask yourself, do I know the law in every state I'm touching? Do I know the exact wording of their prohibited places? Do I know if they have a duty to inform? Do I know their rules about carrying in a vehicle? If the answer to any of those is no, you are not ready to travel. I want to hear your stories in the comments. Have you ever had a close call? Have you ever been stopped while carrying? What state gives you the most anxiety when you cross its border? Let's get a conversation going, because the more we share this knowledge, the safer we all are. The Supreme Court just gave us a powerful tool, but it's up to us to use it wisely. Stay safe, stay informed, and never stop fighting for the rights that so many before us bled to secure.